Weekly Incident Watch, Episode 2. May 8, 2026. Last week ended with a prediction: DeFi United would be tested on neutrality, organization, and legitimacy, questions of governance, not technology. The first test arrived in 5 days. A U.S. law firm has moved to seize the $71 million frozen for KelpDAO's victims, on behalf of a different set of victims entirely. This week is about that lawsuit, and about the 2 structural debts underneath it: the free lunch DeFi has been eating, and the myth that paid for it. The facts. On May 4th, Gerstein Harrow LLP served a restraining notice in the Southern District of New York, targeting 30,766 ETH, about $71 million, that the Arbitrum Security Council froze on April 20th. Those are the funds DeFi United was recovering for KelpDAO's victims. The next day, Aave LLC filed an emergency motion to vacate. The plaintiffs, a victims group holding over $877 million in default judgments against North Korea over terrorism cases. In plain terms, terrorism victims are trying to seize the recovery funds of DeFi victims. The timeline that led here. April 18th, the exploit. A fake DVN message mints 116,500 unbacked RCTH, $292 million. April 20th, Arbitrum's Security Council freezes the 30,000 ETH the attacker hadn't yet moved off-chain. Late April, DeFi United forms. Aave Labs leading, Compound, Lido, Layer 0, EtherFi, and Morpho joining, over $300 million in relief aggregated, with Aave's Delaware entity taking the legal lead. May 3rd, a technical recovery plan. May 4th, the restraining notice. May 5th, the countermotion. What is a restraining notice? Under New York law, a creditor's attorney can directly freeze a debtor's assets held by a third party, no additional court order needed. Ignore it, and you face contempt. A bank robbery makes it concrete. A robber hits Bank A and stashes part of the loot in a safe deposit box at Bank B. Bank B notices and freezes the box. Bank A negotiates for the return. Then a third party appears. That money belongs to a criminal organization. We hold a separate judgment against them. We're claiming it. Arbitrum is Bank B. Aave is negotiating for the victims. Gerstein Harrow's clients are the third party. 4 disputes decide this. 1. Who owns stolen assets? In property law, theft doesn't transfer ownership, so the ETH still belongs to the users. That's Aave's central argument. The plaintiff's counter is sharp. Then who, exactly, represents those owners in court? With no individual users present, the asset is legally unclaimed, and an unclaimed North Korea-linked asset is attachable by terrorism judgment creditors. 2. Does the Terrorism Risk Insurance Act reach crypto? Blocked assets have meant bank accounts and real estate. There's no precedent. 3. Aave LLC can represent its own users, not every KelpDAO user globally, and the plaintiffs target exactly that gap. 4. Whoever wins in a U.S. court takes it all, while victim groups in Seoul, Tokyo, or London hold analogous claims. That's a global unfairness in itself. And the stage was set 2 days later. Terrorism Labs Q2 report: North Korea took 76% of all crypto hack value in 2026, 577 of $760 million, from just 2 attacks, Drift and KelpDAO. The trajectory is relentless. 22% in 2022, 64 last year, 76 now. The better the proof of Lazarus involvement, the easier the attachment. From here on, every DeFi recovery asset carries the risk of being labeled North Korean property. That's the surface. Now the structure. This article's argument is that the May 5th courtroom is a symptom. The disease is a free lunch. DeFi boasted about efficiency while never paying for defense. With KelpDAO, the bill arrived. Look at what traditional finance pays. U.S. banking spends about $30 billion a year on anti-money laundering and know-your-customer compliance alone. Transaction monitoring, hundreds of millions per major bank. Deposit insurance reserves, hundreds of billions cumulative. Against that, Annual fraud losses run 3 to 5 billion. Prevention outweighs losses 6 to 10 times over. That is the correct ratio. Prevention is orders of magnitude cheaper than cleanup. Now DeFi. The top security companies, Blockade, Hypernative, GoPlus, Forta, Hexagate, have raised under $1 billion cumulatively. Industry annual operating cost, maybe 2 to 300 million. Against that, $3.5 billion in crypto theft last year, and $760 million in the first 4 months of 2026. Prevention is under 1/10 of losses. The ratio isn't just wrong, it's inverted 100-fold against traditional finance. DeFi marketed itself as more efficient than Web 2. The truth, it wasn't paying the prevention bill, so the efficiency was a mirage. KelpDAO alone presented an invoice of $600 million to $1 billion in one shot. That's the anatomy. No defense spending, so defenses were fragile. The attack landed. Recovery had no institution, so everything was improvised after the fact. And mid-recovery, a separate claimant appeared. The bill from a free lunch doesn't disappear. It arrives later, with interest, at the worst possible moment. Second, structural debt, the word decentralization itself. It isn't monolithic. It decomposes into at least 5 layers. Settlement decentralization, atomic finality, the structural elimination of Herstatt risk. Valuable. Censorship resistance, critical geopolitically. Valuable. Openness, permissionless building, innovation speed. Valuable. Those 3 derive from programmability, verifiability, and transparency. But layer 4, governance decentralization, buys slow decisions and diffused responsibility. And layer 5, decentralized accountability, where no one bears responsibility, is purely harmful. Nobody invests in defense when nobody is accountable. The free lunch lives on layer 5. And the industry knows it. In quiet times, the banner reads decentralization, code is law, regulation free. Then KelpDAO happens, and suddenly the Arbitrum Security Council wields emergency freezing power, Aave LLC litigates in a U.S. federal court, and a relief coalition assembles overnight. Decentralization in good times, centralization in bad times, whichever is convenient. Gerstein Harrow is exploiting that contradiction, legally. So consolidate. DeFi's value doesn't come from decentralization itself. It comes from expressing financial contracts, rules, and incentives in code, public, verifiable, composable, programmable finance. Decentralization is one component, and only some of its layers carry value. What's needed is a hybrid, centralized accountability, decentralized execution. Someone answers for the system, the code carries it out. That completes the diagnosis. The May 5th battle is symptomatic treatment. The disease is a prevention gap inverted 100-fold, rationalized by a myth. Next week, the prescription, and it is not, imitate traditional finance. Because of programmability, DeFi can build what TradFi failed to build in 50 years, a benefit-based contribution ecosystem, where transparency and verifiability replace the ability to pay compromise. Benefit-based automatic accumulation, composable track records, industry-wide coordination. That's weekly number 3, alongside follow-up on the Aave litigation. That's Weekly Incident Watch, Episode 2. Check any contract at the Ninjascan bot on Telegram. Proof of concept, investment, and grant conversations are open at the usual address, and the white paper covers the architecture. Next week, the prescription. See you then.